I'm going to be talking to Dave Kahn, who is a lawyer with, I'm going to be talking to Dave Kahn, who's a staff lawyer with Ecojustice, about whether or not oil companies can sue governments if climate policies lead to stranded assets. I mean, this could be maybe billions of dollars, maybe at a global level, even trillions of dollars. So welcome to the interview, Dave.
Thank you very much for having me, Markham.
Well, let's start with just that general question. Can oil companies sue governments for climate policy that causes stranded assets?
Well, unfortunately, I think the answer to that is yes. Many international free trade agreements include provisions that allow companies to sue state actors for changes of regulation or policy that negatively impact their business or their capital assets. And they can do so through these kinds of private arbitrations so there's a whole international business of private arbiters and private arbitrations that are set up. The whole system is set up to hear these disputes and resolve them further to these mechanisms in many international free trade agreements that allow companies to sue governments. So for example, the TPP has those provisions, I believe. Certainly the agreement Canada has with China that Prime Minister Harper signed has agreements whereby Chinese companies can sue Canadian governments for changes of policy that hurt their bottom line. And this kind of thing has happened in NAFTA and where, companies have even involved in this, the asbestos sector have been involved in this, and in the areas where government regulation has removed lead from fuel has become the subject of private arbitration.
Well, Dave, if I was the government, I would be responding, well, yes, Mr. Oil Company, but your products over the course of decades are the cause of this problem. I mean, they're why I had to regulate and legislate in the first place. So the fault actually comes back to you, and not and climate crisis is such, it's a crisis of such a magnitude that we had to take these extraordinary measures, again caused by your actions. I don't know, would that argument fly?
Well, you think it would fly, and it would fly in the court of public opinion, or you think it makes a logical argument. It's similar to what tobacco companies have argued, but the problem is these arbitrations are done completely in private. They are closed to the public. Their decisions are not made public, and they're entirely closed. So we don't know exactly what factors the international arbitrator panel. It's usually a panel of 3 arbitrators that takes what factors they take into account. But I think bottom line is they really look black and white at the treaty and whether a change of regulation has harmed a business interest of a company based in another country that's a party to the free trade agreement further to which this arbitration is happening. So I think the danger is these arbitrators don't look at those sort of extraneous factors, if you will. They look very black and white on whether there's a direct line between, or a correlation between, change of regulation and a reduction in business opportunity or a reduction in the value of an asset. And if there is, then there's an award made, and these awards can be in the hundreds of millions or billions of dollars.
Well, let's talk about an example, and I assume this is that it is an example of what we're talking about, and that's TC Energy, the Canadian pipeline company that's suing the U.S. government for the cancellation of the Keystone XL pipeline. And am I correct in assuming that it's being sued in these arbitration processes?
Yes, exactly. They're further to NAFTA and the USMCA, the successor agreement.
And so what happens here? Okay, so let's say that panel gives TC Energy a $15 billion penalty against the US government because, it did lose money by canceling that project. Does the US government have any recourse? Can it appeal? Can it just ignore the panel? What happens? What can it do?
Yeah, there's not much right of appeal. There will be some kind of an appeal mechanism, I believe, to another arbitration panel, but there isn't really much recourse to appealing to the public court system, because similar to private arbitration agreement contractual terms in private agreements, the parties have adhered to the jurisdiction of the arbitration panel, and so they can't go running, if you will, to a public justice system if they don't like the result. So yes, it could result in a binding award against the United States in that instance. Me and others pointed out at the time that Mr. Kenney was proposing this course of action, and TC Energy, I think, is a little more lukewarm on this course of action. But it bears pointing out, however, that the United States has never lost an arbitration like this with a Canadian company, although it hasn't been the same the other way around. So although this might hypothetically be a route by which TC Energy might recoup their costs for that Keystone XL pipeline being killed, it's attenuated whether they would actually be successful.
Well, okay, so let's say that the oil and gas industry they have a process, they have a case, because clearly government's climate policy will be leading to stranded assets eventually. So the magnitude of the potential claims here is a bit staggering. And what happens if a lot of oil companies sue? All or most of them are successful. The awards are in the enormous sums. What happens? The government just have to pay up?
I mean, hypothetically, they do. I mean, but I think in the end, governments are, national governments are sovereign, and I think if that kind of a situation were to come to pass, I would expect, our Canadian government to pull out of the free trade agreement at issue and refuse to comply with those arbitrary decisions of those arbitration panels. I mean, it would be ludicrous for a government to have to pay out trillions of dollars to companies that have known for many, many decades that they are contributing to the climate crisis, and that there's a reckoning coming, and that there's a transition coming, that there's damages that their actions are causing to the health and existence of civilization. So yeah, I mean, it would be absurd if that were to happen. So I think, in the end, national governments would have to take stock and take control of the situation.
Well, is one of their options on the table? I mean, let's assume that both the US government and the Canadian government face, multiple lawsuits and potentially huge losses. Would it be in the interests of both governments to sit down and say, maybe we need to renegotiate this particular clause of the USMCA or whichever agreement is? I mean, would that be a likely outcome?
Yeah, I mean, in terms of stability, that would be better than pulling out of the treaty itself. But many of these provisions were integral to the negotiations, so it might not be as easy as to simply, as we say in the law, sever that term of the agreement or that provision and let the rest go forward. There may be some horse trading that resulted in those provisions, and so just severing them outright might not be beneficial to one party or the other. But certainly, we can't have a situation where governments are changing policy for the benefit of their populations and for the continued existence of our civilization, and that's opening them up to massive legal liability from corporations that, as you've mentioned and as we've discussed, have had plenty of time to understand the consequences of their actions and to understand the situation that they're finding themselves in.
Well, Dave, thank you very much for your insights into this issue. I know it's just a hypothetical at this point, aside from I think there's a handful of cases before arbitration panels around the world, in addition to TC Energy's action against the US. But let's hope it just remains at a handful. Thank you very much for this.
Yeah, I appreciate you having me on, Markham.